because I think I'm the Flash, that I was gonna talk about all of the Supreme Court cases, but we are only gonna get through the Marshall Court and the Warren Court today. But I would rather go deeper on those two than to just try to cover every single one. Does that make sense to everybody? So I really need your undivided attention today. If you think you're tired after sitting through lunch session and then coming in here, I've been talking all day long. And I just am gonna die next week, I guess, when we're doing it, but that's okay. I'm telling myself the same thing I'm telling you. One more week, Georgia, you'll be okay.
If you die next week, we can't come to your funeral, we'll be studying.
There you go. She's on her own.
We'll just Ouija board it and have you teach us more.
There you go. Okay. I'm gonna back up a little bit. I'm gonna start at 1800. The Marshall Court goes in period 4, and some kids are getting real uptight about what period something was in. This is just how College Board divided this course and how they recommend that teachers divide their course. It doesn't matter if you can't remember if Marshall was in period 4 or period 5. You just need to remember Marshall is from the early 1800s. The first third of the 19th century is when we have John Marshall. Something extraordinary happened in 1800. John Adams was the sitting president. He was a Federalist. And in the election of 1800, a person of the opposition party won the election, unseated him. We call that the Revolution of 1800, when Jefferson defeated the sitting president of another party. And y'all are like, what's the big deal of that? Well, that was the first time in history that had happened without bloodshed. It's still a big deal. In CompGov this week, we've been talking about the election of 2015, where for the first time in Nigerian history, the sitting president was defeated by the opposition party. It is a sign of democracy when that can happen, when the people can say, we don't like the job you're doing, get out, we're going to put somebody else in. Does that make sense? So that happened, but we know that presidents have this period of time, so does Congress, between the election and when the new guys take over. What's that called?
Lame duck.
The lame duck. So several things happened during this lame duck period or during the last. Before we get to all that, we know that John Adams was able to appoint a new Chief Justice of the Supreme Court. The Supreme Court was so weak, nobody wanted to be the Chief Justice of it because they didn't do anything. And so they were just kind of rotating it. There were several different men during Washington and Adams' presidencies. But John Adams puts a strong Federalist named John Marshall as his Chief Justice in 1800. And here's what's ironic about that. John Marshall was a Federalist, a very strong Federalist. We know that the Federalist Party is going to die out by 1816 or be absorbed in the Democratic Republicans by 1816, depending on how you look at it. But John Marshall is going to be on the bench until the mid-1830s. So long after the Federalist Party's gone, we still have a Federalist as Chief Justice of the Supreme Court. So I set the stage with that. And then I want to talk about John Adams' late and Congress's lame duck period. Not only has a Federalist been voted out of the White House, but the Federalist Party has been voted out of control of the United States Congress. They have even less time than Adams in their lame duck period. The election's in November. They're getting voted out in January. Y'all focused? Okay? You with me?
Mm-hmm.
So what does Congress do? What does that Federalist Congress do between November of 1800 and January of 1801?
Stop.
They create a lot of new judgeships. Who gets to appoint federal judges? The president, who right now for this minute is a Federalist. How long do those judges sit on the bench?
Till they die or
For
resign.
life or good behavior. So they say, and I'm making these numbers up, but they say, oh, we've got 15 federal judgeships. We're going to make 15 more. So John Adams gets to hurriedly put Federalists on the bench and they get to stay there for life. What were they derisively called?
The
Midnight judges, with the connotation that midnight before, it actually was in the months before, but we get that image. Well, one of those judgeships was supposed to go to a guy who was going to be Justice of the Peace of Washington, D.C., named
Marbury.
William Marbury, exactly. Well, there's a mix-up in the paperwork, and Marbury doesn't get his judgeship. And the new president, Thomas Jefferson, and his Secretary of State, James Madison, are not going to give it. They're not giving that to you, Federalists. There are already enough stinking Federalists on the courts. Marbury sues James Madison for his judgeship. And in his lawsuit, he asked, and it originates in the Supreme Court because it's about D.C., he asks John Marshall to issue a writ of mandamus. And what a writ of mandamus is, it's a power that grants the courts the power to tell one of the other branches what to do. It was in the Judiciary Act of 1789 that set up our federal court system. John Marshall is in a quandary because he hates Thomas Jefferson, he hates James Madison, and he hates the Democratic Republicans, and he wants William Marbury on that seat. But if John Marshall issues the writ of mandamus and tells Madison to give him the judgeship, what do you think Madison's going to do?
Laugh it off.
Yeah, no, maybe. You think you can? John Marshall doesn't want to look weak. He doesn't want to make the court look impotent. So what's he going to do? He denies William Marbury his seat. And in the opinion, and the opinions are so important in Supreme Court cases because that's where the justices justify their rulings. And he says, I believe, the court believes William Marbury should have been given his judgeship. The court believes that the Secretary of State should, in all decency, give him his judgeship. However, the power of mandamus, as expressed in the Judiciary Act of 1789, is unconstitutional. It is not constitutional for one branch to be able to direct another branch as to what to do. So we have to deem that unconstitutional, unfortunately. There's nothing Jefferson can do about this decision. It looks like a victory for the Democratic Republicans, and it is. But in the long term, judicial review sticks. And so that's a brilliant, brilliant move by John Marshall. The courts will not use judicial review again until the Dred Scott decision in 1857. It is not something they use a lot, but the threat of it is enough to control Congress. Congress is going to get legal opinions. This might be overturned if we pass this. We don't want to pass a law that's going to get overturned. That makes Congress look bad. So just the threat of it is a check on the power of the legislative branch and the president. That they don't want to do something that's going to be deemed unconstitutional. I want to talk now just about some other John Marshall court decisions, and they all go in this time period. He's Chief Justice from 1800 until sometime in the mid-1830s. We know he does Worcester v. Georgia and Cherokee Nation v. Georgia in the early 1830s. The next big one that I want to take some time to explain is McCulloch v. Maryland. It's actually McCulloch. You don't say the in it, but it looks like McCulloch v. Maryland. This is over the Second National Bank. You know that in 1816 we have rechartered the National Bank. One of the branches of the National Bank is in Baltimore, and the government of Maryland, the state government, puts a tax on banking transactions through the Bank of the United States. And the president of that branch of the bank, McCulloch, sues the state of Maryland, saying you can't tax us. The courts are asked to make two determinations. Number one, is a national bank constitutional? And two, if it is constitutional, can Maryland tax it? So John Marshall, again, makes a decision. He says, A, yes, the national bank is constitutional because of what?
It wasn't written against. It didn't write that they couldn't do it.
You're right about that. He's definitely a loose constructionist. It's not prohibited. But there's also a clause in the Constitution that gives us the right to have a national bank.
Necessary and proper.
It is the necessary and proper clause, the elastic clause. Because what he says is, we take money in as a nation, We spend money out. It's necessary and proper that we would have a financial institution to regulate that money supply. Okay, question number 1 answered. Question number 2, can a state tax the national government? Well, even if you don't know the answer to this question, you ought to know the answer to this question. Because if it comes down to the national government versus the state government in John Marshall's court, who's going to win? The national government. He's a federalist. And what he says is the national government is supreme. The supremacy clause, exactly. And the power to tax is the power to destroy. And a state cannot tax an entity of the national government. Do y'all understand that? Okay. Here are some other Marshall Court decisions that you should know. You might see as one of those. It could be a choice in one of your multiple choice questions. John Marshall believes very strongly in supporting business. And so his court is very stringent in upholding the sanctity of contracts. If you and I sign a contract to protect business interest and protect you and me, in that, it ought to take a lot to overturn a contract. If we're pro-business, we want to protect contracts. Does that make sense? And Marshall rules that way. We know Dartmouth v. Woodward was a case where Dartmouth College had received a charter back during colonial times, and so Woodward is arguing that charter shouldn't exist anymore because we're no longer under the jurisdiction of the king, and Marshall says it doesn't matter. It doesn't matter if a contract is signed, it is valid. Even if the government under which it was signed is no longer there, it's still a valid contract. Does that make sense? There's another one,
The bridge?
no, there is a bridge one, but the other contract one that I'm thinking about is, that's a Taney case, right after Marshall. Fletcher v. Peck, that deals with contracts as well. Another case that you might want to know that's really epochal is Cohen v. Virginia, Cohen, and that was where Marshall ruled an action of a state government in violation of the national constitution. He ruled against Virginia in that case. Does that make sense? The one that you knew is Gibbons v. Ogden. In that one, there was a debate. There was a steamboat company that ran between 2 different states. I think it's New York and New Jersey. And one had been granted a monopoly to run by a state, and another one was by another state, and the national government came in and sided with one of the states, and the case goes to the Supreme Court. And what they rule in Gibbons v. Ogden is, if there is a conflict between a state's ability to regulate interstate commerce and the national government's ability to regulate interstate commerce, who wins?
The national
It's John Marshall. The national government wins, absolutely. Okay? Does everybody get Big Gibbons?
Mm-hmm.
Okay. Everybody was hyper at lunch. Now y'all are like sinking. Get out of your sugar rush. I'm going to move periods for a second. Can y'all follow me?
Yes.
Okay. I'm going to move to period 6. I'm talking about interstate commerce still. Okay? So Gibbons v. Ogden under the Marshall Court, period 4, Gibbons v. Ogden says sometimes states can regulate interstate commerce, sometimes the national government can regulate interstate commerce, but if they collide, the national government trumps the state. In the 1880s, we get a case called the Wabash case, W-A-B-A-S-H. The Illinois legislature was full of populists, capital P populists, farmers, and they had passed a lot of laws in Illinois regulating railroads. Well, by the 1880s, most railroads are interstate. They go from one state to the next, correct?
Mm-hmm.
So the Supreme Court, the Wabash Railroad Company says that's not fair, that Illinois can't regulate what we can do and can't do. They take their case to the Supreme Court, and it's the 1880s, it's the Gilded Age. So of course, the courts decide in favor of the railroad company, and they say, you're right. Only the national government can regulate interstate commerce. You with me on that?
Mm-hmm.
They can only the national government can. States can regulate intrastate commerce, but only the national government. Keep your eyes open, okay? Only the national government can regulate interstate. Do we get that?
Mhm.
So now the national government has even more commerce power. Then we get to one of y'all's favorite cases from the Warren Court, which is Heart of Atlanta, VUS. The guy that owns the Heart of Atlanta doesn't want black people staying there. And he doesn't appreciate the Civil Rights Act of 1964 saying that he has to let black people stay there. He says, I'm not, this isn't the Holiday Inn. I don't have a chain all over the place. What does the Supreme Court rule about that?
All commerce.
All commerce is interstate commerce. And so that is a ruling that is really going to give teeth to that Civil Rights Act of 1964.
I mean, yeah, by that point, everything really is interstate.
It really is. There was another case, and I never can find the name of it, and it took place in South Carolina, and it dealt with a barbecue stand. Somebody had a barbecue stand that was only open on the weekends, and they said, listen, we only sell to people from this little rural area. We grow the hogs here. We kill the hogs here. And the courts ruled, well, the mustard comes from out of state. And so you're right. By that time, all commerce is interstate commerce, so the national government can regulate it. I had something I wanted to say about that. Do you know this fact?
Probably not.
The Civil Rights Act of 1964 started in the Commerce Committee of the United States Senate. Wouldn't you think it should have started in the Judiciary Committee of the United States Senate? Can anybody guess why it starts in the Commerce Committee?
Because so many stores and services weren't, like, they didn't serve black people.
Okay, so you're saying that maybe they thought it was a commerce issue more than just a justice issue. That probably had something to do with
Well,
it.
commerce was like an effective way they could implement, like,
They could do it that way. It's easy to tell if you're commercial. There's another reason.
Yeah, somebody really wanted it done and added it as a rider.
Almost. The Commerce Committee was full of Northern liberals. The Judiciary Committee was full of white Southern conservatives. Does that make sense? There's no way in heck the Civil Rights Act is ever getting out of the Judicial Committee. But it got out of the Commerce. And that's why private places can still discriminate today. You can have, we don't let schools, because we said that there's funding, but we don't let schools do it by race. But we let schools do it by gender. We let schools do it by religion, right? Because it didn't come out of the Judiciary Committee. It's a Commerce Act.
I have a question, because I grew up in Pinehurst, North Carolina, which is where the Masters was a few years ago and everything. So there's a lot of golf courses, and I just remember this one golf course that they would not let, like, it was 2008 or whatever. They wouldn't let like black people on their golf course. Is that unconstitutional and no one's
Yes. Well, I say that no. They could they could do that because it's a private golf club. Just like Augusta National, where the Masters are, they don't let women in it. I think maybe they let one last year or something. They finally have, and they discriminated against black people for years too. And then it was like the PGA is like, we're going to take our tournament away. We're not going to, and they caved to financial pressure. But because it's private, you can discriminate.
So is that why there was like the Boy Scouts of America were able to keep it boys until just recently?
Yes.
Just because it was
Yes.
private.
Yeah. But they take grants and stuff from the federal government, so that got overturned. I need to go quickly.
Is
I'm
that
sorry.
like clubs of people, or is that like businesses?
Businesses aren't private.
Yeah, okay.
If you know what I'm saying? Now that was a private club. We came together and we jointly owned the club. Like there was and I hesitate to call it a country club in Holley Hill because that's kind of oxymoronic. But anyway, there was one in Holley Hill, and you had to buy. You had to be an owner of the club to be a member of the club. You had to buy stock in the club to be a member of the club. All right, I got to go to Warren Court decisions now, so I'm jumping forward 150 years. What is Earl Warren's first big Supreme Court case as Chief Justice? 1954. Brown v. Board of Education. And he is very instrumental. He's not just the Chief Justice. He makes his decision, we need to desegregate schools, and he goes around and convinces all the other justices. Okay? So we know Brown v. Board. Here's a grocery list of other ones. Some of them you know, some of them you don't. We get Map v. Ohio, and that is incredibly influential because it was the national government telling state and local policemen what they can and cannot do. If the police come into Leah's house illegally, Conway police, I don't know where you live, Leah, but they come into your house illegally and they find all these bloody clothes and a bloody hatchet and a map to a pasture somewhere. And so they take that map and they go to that pasture and they start digging and they find hundreds of bodies.
Leah, what you been up to?
Leah, it's okay if you did it, Leah, because you're going to get off of it. You're not going to be convicted because everything that came out of that original illegal search cannot be used in a court of law. It's called the fruit of a poison tree. That's what whoever wrote that decision, Mount v. Ohio, used that terminology, the fruit of a poison tree. Let me go ahead and do the rest of them.
Was that the porn one?
That was the porn one, and that's unfortunately that's how y'all remember it from last year. But it's really not about porn. It's about she was arrested on pornography charges, but she argued that they found the pornography after an illegal search, and so it got thrown out. You know Gideon v. Wainwright, states have to give you an attorney if you can't afford one. You know Miranda v. Arizona. You have to, anybody who's watched one episode of Law and Order knows Miranda v. Arizona. We get Loving v. Virginia, which is interracial marriage. It overturned state laws banning interracial marriage. We get Griswold v. Connecticut. Are y'all hearing a theme here? What?
Someone versus states?
There is somebody versus the states, and these are all examples of incorporation where the Warren Court is forcing the states to uphold the Bill of Rights. Griswold is birth control. We get Engel v. Vitale, which is school prayer. We get Tinker v. Des Moines, which is armbands, which is basically freedom of speech of students.
Lopez, right?
That's 95. I'm trying to think. That's another big one. We get Heart of Atlanta.
This is related to like the Des Moines one. If students have free speech, like based on what they're wearing, how come some public schools still have uniforms?
They have free. Here's what the decision said, and it's one of those that kind of is and kind of isn't. They said yes, students have freedom of speech. However, the administration can decide if that speech is disruptive to the school environment. And so it gives the administration that power, which is broad. I want to tell you, yes.
Was Roe v. Wade?
No. I'm going to tell you that. Yeah, we so want to put Roe v. Wade in this one. It's burger court, and I will tell you 3 in the burger, but I got another one of these.
Bong Hits for Jesus.
No, that's like 2000s.
Oh, really?
Or late 90s. Okay, are you with me?
Mm-hmm.
Okay, I want to tell you about one that we've not studied before that I was remiss. And some of you who were here the other afternoon heard this one. It's Weeks, Weeks v. Southern Bell. Lorena, we looked her up. Lorena Weeks had worked for years for the Southern Bell Telephone Company. She started as an operator, then she moved into a job as a secretary, and she wanted to get a much higher paying job with Southern Bell of checking the phone lines, being a lineman to make sure that they were working. And she was told that she could not take that job because she was a woman. And she said, well, that's discriminatory. That goes against the Civil Rights Act of 1964. And they said, well, women can't lift over 30 pounds, and you have to be able to do that. And she said, well, every morning as a secretary, I have to lift my typewriter and move it to this desk. So obviously you're saying women can't be required to lift over 30 pounds, and my typewriter's 34 pounds, so I'm not typing anymore. And they're like, well, we're going to, they threatened her job. I don't know if they actually fired her or if they just threatened. So the newly formed, this case is 1966, the newly formed National Organization of Women agreed to help her in her lawsuit. They provide her legal fund to be able to fight this all the way to the Supreme Court, and she wins. So this is a major case in the fight for women's equality in the workplace. It's also another case like Heart of Atlanta that upholds the Civil Rights Act of 1964. Does that make sense to everybody? All right.
What kind of logic is that? Like, what human can't lift 30 pounds?
Well, and that's what people said. They said, what woman doesn't lift her 30-pound child, toddler or something on a regular basis? It was, people didn't mind. There's another case, and don't write this one down, but there's another case like in the 80s or 90s where a female newscaster was told that she was being let go from a local television station because she was approaching middle age. She was in her 40s, and they said, people don't want to see that. And she sued over two things. She said, number one, I can read the news even though I'm approaching middle age, and number two, you aren't firing the male newscasters when they hit middle age. You don't have those same restrictions on men, and she won her case. And there've been loads of gender discrimination cases since Weeks v. Southern Belle, and there's some cases where it's upheld. Victoria's Secret doesn't have to hire male models to model their bras and underwear, or things
That'd be
like
so
that.
funny.
But the Supreme Court or our lower courts hear them on a case-by-case basis. And something else. Let me tell you 3 Burger Court decisions. Earl Warren is Chief Justice from 54 to I think 69. And then we get Warren Burger, and he's the Chief Justice from, I believe, 69, somewhere up until the late 70s, early 80s.
That's confusing.
I know. It's just to confuse us. So let's just don't even worry about their first names. Let's just say Warren, then Burger. Does that help? Okay. Think about like people streaking in the 70s. Do y'all think of the streaking in the 70s or disco eating a cheeseburger? Does that help? Okay.
Naked people eating cheeseburgers.
Yeah, that's a great image.
Making people at the disco while eating.
There you go. Now we got all the stuff from the 70s with Watergate on in the background of the television.
Yeah.
Here are four
open
Burger Court decisions for you. First and foremost, tattoo it on, not on your arms because that would be cheating, but learn it, is Roe v. Wade. Roe v. Wade is not a Warren Court decision. We want to make it a Warren Court decision. It is possible because of a Warren Court decision, Griswold v. Connecticut. Did we say Griswold just now for Warren?
Yes.
Because they established the right to privacy, but it is definitely a Burger Court decision. Roe v. Wade, Burger Court, 1973. Know it. Know that. Another one is Yoder, and I actually told First Block, so I've got to amend this next week. I told them that Yoder v. Wisconsin was a Warren Court, but it's a Burger Court. It's 1971. That was where the Amish people, the Yoders were Amish, and Wisconsin said they had a 16 or 17-year-old dropout age for kids, and the Amish expected once their kids hit adulthood, which they classified as like 14, that they shouldn't have to go to school. And the national government, the Burger Court, keep with me. I know you got to go to class. We still got 2 minutes. What y'all doing?
I don't know.
Crazy people. Y'all not going to college classes? So Yoder is a Burger Court decision. You can think about Yoder.
Wait, what'd they rule?
They ruled that the Amish can keep their kids home, that the Wisconsin law was unfairly criticizing them. A third one that you know about religion is the Lemon v. Kurtzman case. So Lemon, Yoder, Roe are all Burger Court decisions.
What was Lemon again?
I don't remember the details, but it establishes the Lemon test, which asks those 3 questions. Is it overly invasive in religion? Is it overly... Y'all remember that? It set the standard for separation of church and state that the courts still use today. There's one more Burger Court case that y'all know, and that is Bakke v. Regents of California, Bakke. That was the guy, I can't remember, it was some kind of graduate school. Was it medical school or law school? I want to say medical, but don't write that down. Bakke is applying and he doesn't get in. And he says he doesn't get in because they were reserving X number of spots for African Americans. And he is challenging affirmative action. And this is another case where the court kind of splits 50. I don't mean there's a 5-4 decision, but they kind of give a little bit and take a little bit, like the Tinker case. They say you cannot have quotas that let people get a position strictly based on their race and entirely based on their race. However, it can be a factor. In other words, you can grant some points to people if you want some kind of ethnic diversity. And we see that a lot still today, guys. When you apply to colleges, you are more likely to get into a college in Oregon than you are in here a lot of times, because a lot of colleges want geographic diversity. I know a kid from South Carolina that got a full ride to Tulane and did not get a full ride to Clemson. And Tulane was at that time a much more prestigious college, or selective, I should say, college in New Orleans, because they wanted geographic diversity. It's why our kids have such a hard time getting into Duke. Duke's got all the Southern people they need. They need people from Washington State.
This is like off topic from Supreme Court cases, but why did people think affirmative action is a good idea, like mandating that colleges like accept this many black people and this many white people? Is that still like discriminating with race?
It is a what the courts have decided and what people argue is that a college has a right to try to create a certain population. For example, you might get more points in your college application for what your major is going to be. If that university is looking for more of history majors and less engineer majors, because that would be a perfect world, right? If that, but whatever they're looking for, they may grant more points. A university can create the atmosphere they want. If you are a white or Asian or Hispanic and you're applying to a historically black college, you have a better chance of getting in than an African American does, because they want to bring about diversity. Does that make sense? And so what you have to do now, like the two Michigan cases, Bollinger, there were two against Bollinger that y'all studied last year, where they were attacking the University of Michigan's graduate and undergraduate. You have to prove that it over those number systems that they use. We use a number system to get in here, but we don't do any kind of quotas. We don't know whether you're a boy or a girl, whether you're from Conway or Myrtle Beach, what your race is. All we know is your data.
I mean, that's like more fair though, because then you're just getting in on your merit.
You're assuming that a college only wants the smartest people in it.
Well, they should.
Well, they might not. They might understand. They might believe that diversity helps growth. That might be their goal.
Diversity is our strength. The
All
slogan
the
of
smart. You have to meet a certain level to get in Harvard, and after that, it's everything else, because they've decided that the highest people don't do any better than the people at the minimum of what it takes to do well at Harvard. Anyway, have a good weekend. If I'm not seeing you tomorrow, I'll see you tomorrow.